very, very quiet, as usually is in August. Most people are away on vacation. Some people are getting ready to send their kids to school. And of course, there's all this uncertainty going on as to what's going to happen in the fall with COVID. Are people going to have jobs, not have jobs, you know? So there is a lot of things happening. But there is reason to continue to be optimistic because immigration has been changing in a very positive way. Those changes they have been talking about, and they are continuing to be implemented by the Biden administration. The only thing I'm going to also touch upon today, because I've heard this over the last week, the last place that we are experiencing delays, the most delays, there's delays everywhere, and the last place that we're having the hardest time working with now are the embassies. The embassies continue to be understaffed. They are working at limited capacities. They are not interviewing people outside of the countries where the embassy is located. So we've run into problems that a person from country X, where an embassy is closed, can't get an interview in a country Y where an embassy is open, because country Y wants to only interview the citizens and residents of country Y. It is not uniform. It is not across the border. We have some embassies that are willing to accept certain types of cases, but it is a case-by-case basis. And I know that people are very frustrated, especially when they hear that others are coming. But unfortunately, it's a matter of time. Things will get resolved. It may just take longer than what you have expected. That is the opening. Now, last week I got a question about follow-up on waivers. So let's say you did a waiver because you have used fraudulent documents, and you have somehow misrepresented a fact to the U.S. government, and you had to file a 601 waiver. Let's say the waiver was successful and you have your green card and you're now ready to apply for citizenship. Will this come up? Yes, it will come up. As I told you before, you have one immigration file and only one immigration file. So the officer who's going to be reviewing your citizenship application will see that you have had a waiver and will have, a chance to take a look at it. They will not ask you what was in the waiver, or whether you're still with the person, or the circumstances still exist under which you have obtained the waiver. No, they're not going to what's called re-adjudicate the waiver. They're not going to ask you for that waiver again or updated documents. But the citizenship application does contain questions such as, have you ever misrepresented a fact or produced a fraudulent documents and submitted it to the immigration officials, right? Have you ever done a misrepresentation? And one of the biggest issues that I see people coming to me with is, they went through the hard process, as they think the hard process, with an attorney. They got the waiver, but then for the citizenship, they're like, I'll do it myself. They go to the interview, and some people get nervous, some people don't understand the legal consequences or the question that is being asked. And when an officer says, have you ever misrepresented a fact? Have you ever lied to a U.S. officer? They say no. And then the officer denies their citizenship application, because at that point, they have lied to an officer again, okay? And for citizenship purposes, you're supposed to show that you're a person of good moral character for 5 years preceding your application. So if you're applying in 2021, you have to show that you're a person of good moral character for the 5 years preceding this year. So when you go to the interview and you answer no to a question that should be answered yes, the officer has the right and will, in certain circumstances, deny you. And the largest amount of denials in that aspect that I see is when the officer asks the person, have you ever lied? Have you ever used a different name? Have you ever, misrepresented yourself? Have you ever used a fraudulent document? And the person consistently says no, even though they did and they admitted it and filed a waiver. So Jimmy, that's the person who posted the question. I hope that answers the question. If you have any follow-ups, feel free to reach out. Main story today, we'll talk about asylum and eligibility for work permits when you're an asylum applicant. I have my little cheat sheet with me because it's a lot of information. But I will give you the gist. I'm not going to bore you with legal precedents because most of our clients don't really care about that. They just care about the bottom line, what can be done, what is possible, what's happening. When you apply for asylum, under current regulations, you come into the country, you have to apply for asylum within 1 year. Let's say you came in and you have applied for asylum. From the date that your application is deemed to be pending with the asylum office, you can only apply for work authorization 365 days after, right? Number two, and this has come up in the last 2 weeks, if you have applied for asylum and have not attended the interview and 365 days have gone by, you can still apply for work authorization. You do not have to have attended the interview in order to be eligible for work permit. That's number two. The Trump administration, when changing the regulations on work permits, implemented various grounds for denying or exercising negative discretion in issuing EADs. So the first thing was the 365 days that they implemented, that you now have to wait an entire year before you can apply. Two is they now charge you a fee to apply even the first time. It used to be that your first work permit application as an asylum seeker was free. That's gone too. Two, they said that they can deny work permits if there are any delays that were caused by you, the applicant. What are the delays? For example, if you changed, if you have amended the application, decided to amend the application right before or at the asylum interview, and that caused the delay. If you submitted evidence for your asylum application too close to the date of the interview, and that caused the delay. If you are changing places where your case is being done because you've moved from one state to another, that causes a delay, and that can be grounds to deny your work permit. Another one, under the regulations, when you attend an asylum interview, you're supposed to come at a given date, which is going to be provided to you by the asylum officer, and pick up your decision. If you don't pick up, they will mail it to you, right? But then now they consider that to be a no-show, and your work permit can be denied if you did not show up to pick up your decision. Now, if the asylum office told you that the decision would be mailed to you, which is the case now under the COVID regulations, that obviously doesn't affect you. It's only if you were told to come in person and didn't, that affects your case. That's that. Next, they will deny EADs, can deny EADs if you have entered the country without inspection. That was one of the biggest ones. The background to that, of course, was discouraging illegal crossings of the border, right? So if you entered through the border and then in United States applied for asylum, they're saying that they would deny you work permit based on that. Number two, if you've been in the country for more than a year and then applied for a work permit, they would deny your work permit unless a judge or an asylum officer has made an explicit determination that you actually fall within one of the exceptions, right? Because we've covered this before. The rule is that you have to file within 1 year of arrival to the US, but there are circumstances that excuse the later filing, right? Change in personal circumstances, change in country conditions. I've covered that before. It's in one of the videos. So what they're saying is, if you've been here for 10 years and then you apply for asylum, you will not get your work permit unless and until either an asylum officer or a judge determines they actually fall within one of the exceptions to the 1 year filing deadline. The background to that was that they were, of course, trying to discourage people from filing for asylum in order to get into removal proceedings and then file for cancellation of the green card, or as is commonly referred by the general population as the 10-year residence green card. There's no such thing. It's a very limited type of relief that's only available in very limited circumstances. I'm gonna talk about it in one of the videos. Three. If under general rule, the way that it was before and the way that it is now, let's say you applied for asylum, your case is pending, you're getting your work permit. Let's say you go before the immigration judge and the judge denies your asylum application, and then you make the decision in your appeal with the Board of Immigration Appeals or the BIA. You're allowed to continue to renew your work permit while that appeal before the BIA is pending. However, the change in the regulation is that if you have applied for asylum and the judge denied your asylum within the first 365 days and then you appeal, you won't become eligible for a work permit at that point at all, unless the BIA agrees with you and grants your asylum application. That's the third one. Now, this one, it's kind of hard not to agree with, and of course, there will be people who disagree with me, but your EAD can be denied on discretion if you have serious criminal convictions, aggravated felony, or serious felonies, whether inside or outside of the United States, if you've been convicted of domestic violence, if you've been convicted of child neglect or abuse, and if you have been convicted of a controlled substance offenses. Okay, so that is considered to be serious under any circumstances, and those are the crimes that the judges pay the most attention to. And some of these crimes, such as aggravated felony, can make you ineligible for almost any form of relief in the United States, and a lot of the crimes that I have just listed can make you ineligible for asylum and other forms of relief based on discretion, right? So they're kind of just saying, like, since we have, or the judge or the USCIS has the ability to deny you the underlying relief based on these crimes, then we're going to take them into consideration when giving you the ability to work in the United States as well. Now, those rules have gone into effect last summer of 2020, right before, kind of still during the Trump administration, right? That was still sometime before the election. We didn't know what was going to happen. But these regulations remain in effect with a very small exception. There was a lawsuit. The regulations were challenged by Casa de Maryland and ASAP. They are two not-for-profit organizations. They sued the Trump administration, and in that lawsuit, the judge granted a very narrow, very specific exception what does the exception say? If you are a member of one of those two groups, Casa de Maryland or ASAP, then what doesn't apply to you is the 365 day, the 365 day waiting period, which means that you, if you're a member of those groups, can file after the 180 days. Number two is that you don't have to pay the fee when you're filing the first time. And number three is that USCIS has to process your work permit within 30 days. The whole 30-day processing time, I will explain to you now, but just remember that if you're a member of those groups, two things that are going to be taken into effect. One is whether you were a member of the group at the time that the judge issued the decision. I have to tell you that we have been successful in having people join after the fact, apply for work permits, and still get them. So that has happened, but that is subject to change and review and discretion, and in some cases can start being processed differently. Number two, if you're a member of those two groups, that does not take away all other grounds that make you ineligible for work permit that I have just covered. So if you enter through the border, or you have criminal convictions, or if you've caused delays, or you've been denied, or you've applied after the 1 year, none of those are covered by that settlement. That settlement covers narrowly only three issues, right? So that covers only the 365-day waiting period, the fees, and the processing time. Let's talk about the processing time. Originally, under the regulations, the whole point for the work permit for the asylum, for people who are seeking asylum, one point that I want to make, and please take this the right way, the work permit is not your right. The work permit is a discretion that the U.S. government is providing you. The whole point of the work permit was that they understood that a person is seeking asylum, there are delays in processing, and that person should have the ability to support him, herself, and their family while they're waiting for the processing of the case, because they're not the ones responsible for the delay. That's kind of the gist of it. But your work permit is not a right. There's no such thing as, I'm here, I'm in the United States, they have to give me the ability to work. That is not the case at all. So you have to treat a work permit as a privilege, as a driver's license. When the state gives you a driver's license, you have to go through testing and show them forms of ID and stuff like that. Just because you moved into the state and bought a car doesn't mean you're entitled to driver's license. Work permit is treated the same way. So, originally, all work permits that are given to asylum applicants were supposed to be processed within 30 days. The Trump administration changed the regulation that said, no, we don't have to process it within 30 days. We could take time, there are delays, we can't strain our resources in order to accommodate this one specific group of people. So the processing times were crazy. People were waiting for 6, 7, 8 months just to get their first work permits. We're not even talking about renewals. And they would get their work permits for 1 year, they got it, and then 6 months later, you already have to pay another fee in order to renew it. So all of that, go do the biometrics again and all that stuff. So all of that obviously puts more pressure on the applicant. They have to take the time off, to come see the attorney. Not in our case, we provide everything electronically, but in general, to go do the fingerprints, to take pictures and stuff like that. So that provides a burden on the applicant, of course. So the other thing that also is within the settlement, only if you're a member of those two groups that I just mentioned, the 30-day processing period is restored. So if you're a member of those two groups and you have applied for work permit, it's your initial work permit, it's gonna get done within 30 days. And I have seen that it actually is done within 30 days. Our clients were receiving things promptly. A lot of information today, fun. So you can watch this video over and over again and see if you know, will have any questions, because I know, you know, it's a lot, not the best, especially if you're an asylum applicant, not the easiest news, but it is the law of the land, so to speak, and we have to work within the parameters that are given right now. We haven't seen any indication from the Biden administration that this will be changed or when it will be changed, or, you know, they seem to be having other priorities. We don't even know if they will change all of this or some of it will stay. So you have to assume that for now, this is the regulation, and as it comes to your work permit if you're an asylum applicant. Right, so if you have any questions about this, you know, comment here or on our YouTube channel and I will get back to you. That pretty much concludes what I wanted to talk to you about today, but I do want to make an announcement. Today at 2 p.m., my partner Ibrahim Hamra and I will be speaking live on Instagram, and we will talk about the withdrawal of troops from Afghanistan and where does that leave people who are in the process of immigrating to the US, and where does that leave people who, you know, have cooperated and worked with Afghanistan and, you know, will have some information, hopefully, that is going to be interesting to people, even if it doesn't specifically apply to you. You know, you may know somebody, you may just be in general interested of what's going on in the world. I'm happy to see everybody here today. Next Thursday, I will not be here, but my esteemed associate, Wendy Barlow, she will talk to you about something very, very interesting. I promise you, you're going to love it. And we will tell you what it is going to be sometime early next week. I hope everybody enjoys the last weeks of summer. No, I'm very sad. I actually am. I love the summer. Before we jump into the school year, and then the holidays are going to be around the corner, and you know, we're going to continue to have all this fun through the end of the year. So I hope everybody's going to enjoy the weekend, you know, their time in the sun. Hopefully people will have time out, and the weather's going to cooperate with us. But I, as always, am very, very happy to see everybody here. Please feel free to reach out, emails, Instagram, Facebook, YouTube, Twitter. We're everywhere. You can even find us on LinkedIn, and we're happy to hear from you. Thank you very much, and everybody have a great day.